Good day, everyone, and welcome. My name is Dan Sampaio, and I'm delighted to open today's Mondac webinar in association with AG Paphitis Co LLC. Today's webinar brings you a comprehensive guide to mergers and acquisitions in Cyprus. We are joined today by an excellent panel. Angelos Paphitis is the managing partner of AG Paphitis Co LLC and leads the firm's commercial and corporate practice. Maria Hinney is a senior associate within the firm's M&A and corporate and commercial departments. Elena Canarini is a senior associate within the firm's FS regulatory and compliance department. Andrea Passara is a lawyer who has extensive experience in the areas of corporate and commercial litigation, arbitration and insolvency. Michael Alexandru is heading the tax practice of the firm. He is a member of the Institute of Association of Chartered Certified Accountants and a member of the Institute of Certified Public Accountants in Cyprus since 2009. And completing today's panel is George Tashev. George is an associate lawyer at AG Paphitis Co LLC. Before I hand over to our panel, here is how you can get involved in today's event. You have the opportunity to submit questions to today's presenters by typing them into the questions pane of the control panel. You may send in your questions at any time during the presentation, and we'll address as many as possible during our Q&A session at the end of today's presentation. I would now like to hand you over to our speakers to begin today's webinar. Thank you.
Thanks, Dan, and thanks for the great introduction. Let me just say that I am delighted to be presenting this webinar with my colleagues George Tashev, Elena Canarini, Maria Hinney, Michael Alexandru, and Andrea Passara. In a nutshell, George will open this webinar with a briefing about Cyprus and the current market trends in Cyprus. Elena will be following with the legal framework and regulatory provisions in respect to mergers and acquisitions in Cyprus. Maria Hinney will then take over, who will give us a quite in-depth analysis on Cyprus M&As and on their process through to completion, including the do's and don'ts, not only on M&As as such, but also on joint venture structures too. Maria will then pass over the presentation to Michael, who will give us a very interesting presentation on tax matters in relation to M&A deals through Cyprus. And last but not least, Andrea will focus on the exit ways from an M&A deal, with particular analysis on the Cyprus court system, what an oppressed partner to an M&A deal should be aware of, and how he or she can be protected through the Cyprus legal and court systems. Following completion of slides, a questions and answers section will be available, and of course we will be happy to answer any questions. If I may, I will do a very small introduction. You see, when we were thinking about this webinar, we were all quite puzzled whether to do a traditional presentation on M&As or should we focus on a more practical discussion. We then decided to go practical, and that's how the title came up: Law and Tax, Insights, In and Out Strategies. We've concentrated our presentations on giving a better understanding on technical details so that an attendee can get a full picture on what an M&A through Cyprus requires, what to do and what not to do, and of course, how will an M&A through Cyprus benefit the deal. You will note that I am mostly making reference to M&A through Cyprus. The reason I'm doing this is because, in fact and in reality, Cyprus is not a country with most M&As focusing in the Cyprus market as such. We do see such M&As, of course, quite a lot, mostly around banks and non-performing loans and the tourist industry, followed by real estate and energy. But if one will compare M&A deals made through Cyprus on holding companies level, when Cyprus companies are in fact the SPVs for a foreign acquisition or a foreign investment, then of course the number of M&As through Cyprus compared to M&As in Cyprus is quite incomparable. You see, Cyprus offers one of the best and most easy tax systems in Europe, not to say in the world, especially when it comes to a holding company's level. My call will focus on tax, but what's important to point out now is that Cyprus is most certainly the best option when considering investing through M&As or joint ventures in any foreign asset, mostly when acquiring shares in a foreign company. Foreign colleagues who have been working with us for many years on this kind of structures are well aware of the unique benefits that Cyprus offers in respect to M&As through Cyprus. So the idea of this webinar is to concentrate on these very particular benefits. Before passing over to George, I will very quickly say that the last 12 months have been unprecedented in various matters, and of course, it touched the M&A market too. One may say that 2021 and 2022 will be the years of distressed M&As, something which will increase the sales through M&As, but also the risks. The areas who have mostly been affected are the travel and hospitality, who may be forced to sell, but also family businesses who will opt to reshape their businesses following COVID-19. It is my firm belief that mergers and acquisitions will have a substantial increase from now onwards, so structuring them properly is our target. I will not take more of our time. At this point, I would like to pass over to George. George, the stage is yours. Thank you.
Thank you, Angelos. Hello to everyone. So I'll be speaking a little bit about Cyprus as a business environment and as a jurisdiction. Firstly, it's very important to note that Cyprus has become a very significant business hub. This is because of its professional yet flexible approach, friendly business nature, hardworking ethic, and commerce-conscious approach. This includes appropriate government regulations and a general policy of efficient business operations. The country's legal system is based on the Constitution of 1960 and is closely related to that of the United Kingdom. All statutes regulating business matters and procedure are based on English common law, with most laws also officially translated to English. With an economy built around foreign investment in the form of tourism, import, export, and relocation, either on a business or personal level, the island is a diverse hub connecting all points of the world. Its strategic geographic location between Europe, Asia, and Africa brings interest from businesses all around the world looking to utilize access to the various markets. The economy has shown resilience time and time again, overcoming any and all challenges. The most recent example of this is the COVID-19 pandemic, where the country is already showing signs of recovery. This can be attributed to a low population and a hardworking, highly skilled community. Cyprus has implemented regulations through EU directives to ensure transparent and safe business operations, with also human talent being one of the island's most compelling advantages. Moving on to the next slide, please. In 2004, the country became a member of the European Union, and then later in 2008 joined the Eurozone. By doing so, it also became the most eastern point of the EU. Based on English common law principles, which we will cover in more depth later in the webinar, Cyprus has implemented a comprehensive and robust legal framework, which is widely recognized as a business-friendly and effective system that ensures transparency and reliability in business practices. Offering foreign businesses a familiar and reliable framework within which to operate, Cyprus' legal system is also fully compliant with the EU on money laundering through the EU AML directives, and not only. Its EU membership ensures safety and stability for investors, also offering them market access to more than 500 million EU citizens. It gained access to significant endorsements and funds, resulting in boosting the economy and further strengthening the infrastructure. Additionally, the Cyprus government over the years managed to establish both political and economic ties with our non-EU neighbor countries such as Israel, Egypt, Jordan, and the UAE. Due to its strategic location and the diplomatic relations with highly developed countries, Cyprus continues to flourish in the economic sector. The island exhibits strong GDP growth for the 5th year in a row, maintaining its status as one of the fastest recovering economies in the EU. Foreign direct investment is also attracted by the competitive low corporate tax. With only 12.5% corporate tax, it's a huge incentive for companies to choose to relocate to Cyprus and avoid higher taxation. As a dynamic business center, Cyprus offers an abundance of highly educated and skilled individuals, multilingual in their majority, and this can help develop businesses in a more effective way. It offers an enviable lifestyle in a safe, clean, and healthy environment with high living standards. It has one of the lowest crime rates in the European Union, with safety being among the biggest advantages of the island, and has been ranked the 5th safest country in the world in 2020. Next slide, please. The economy of Cyprus is based on 5 main pillars, which are tourism, trade and transport, real estate, innovation, and financial services. Tourism has been one of Cyprus' top financial performers for many years. It is important to state that in 2019, Cyprus had welcomed almost 4 million visitors, with a total revenue estimated at 2.7 billion euros, placing Cyprus as one of the most attractive European holiday destinations. As an island nation, there is a large reliance on transport links via massive air connections and multi-purpose ports vital to import and export activities. Further to this, it has an outstanding reputation as a maritime center as well, and has built on that experience to develop the Limassol port into a state-of-the-art facility, equipped to compete with regional rivals such as Haifa, for example. The government has an unwavering commitment to innovative research, and its rapidly growing startup ecosystem is supported by a generous support package with state and EU funds to spend on a number of key projects over the next 3 years. These funds will go towards various initiatives, including the creation of new innovation clusters to bring together entrepreneurs, researchers, and academia, as well as digitalizing over 160 state services and cybersecurity projects in the country. Finally, with over 30 local and international banks operating on the island to facilitate the needs of every transaction, the financial services sector is highly developed, creating an ideal business environment for companies interested to operate in the sector. We have many international key players which have chosen Cyprus as their ideal location to base their headquarters in. And with that, we conclude the introduction to Cyprus. And back to you, Angelos.
Thank you, George. Very interesting short analysis about Cyprus. Elena.
Hello, everybody. Thank you for joining us. My mini presentation focuses on the legal framework applicable to public and private merger and acquisitions in Cyprus. The most common M&As in Cyprus are private ones, whereas public M&As do take place, but not that often. M&A process is constantly adjusting to the ongoing amendments in the laws and regulations. In specific, the recent amendments on the AML law, the increased focus on the GDPR, the implementation of EU directives into national law, and the wide-ranging tax law changes have affected the M&A practice. A quick overview of the applicable laws will follow up, starting from the key legislation on M&As, which is the Companies Law. The Companies Law regulates internally mergers, transfer of assets, exchange of shares in 2 or more companies that intend to merge together, mergers of public companies in compliance with EU rules, and cross-border M&As. Regarding cross-border M&As, please note that given the complexity of cross-border mergers and the multiple interests concerned, the competent authorities ensure that a decision on the approval of a cross-border operation is taken in a fair, objective, and non-discriminatory manner, and on the basis of all relevant elements required by union and national law. Recently, a new directive of the European Parliament and of the Council came into force regarding cross-border conversions, mergers and divisions, which strengthens the protection for employees and allows all stakeholders' legitimate interests to be taken into account in the procedure governing a cross-border operation. Cyprus, as member state, is expected to implement this directive into national law by 31st of January 2023. Analysis of the relevant provisions of the company's law will be provided by my colleague Maria Hini later on. So we're now moving to the next slide, where you can see other relevant laws and regulations applicable to M&A transactions, which include transparency law, takeover bridge law, which applies to public M&As, the market abuse law, the purpose of which is inter alia the preservation of market integrity, the control of concentrations between undertakings law, which regulates concentrations and protects the functioning of competition in the market, the Corporate Governance Code issued by the Cyprus Stock Exchange in relation to listed companies, the preservation and safeguarding of employees' rights on the transfer of business, facilities, or parts of business or facilities law, which protects employees' rights on the transfer of a business. Next slide, please. So the key regulators for M&A structuring are Cyprus Stock Exchange, Cyprus Securities and Exchange Commission, and the Commission for the Protection of Competition. Another relevant body is the Registrar of Companies and Official Receiver, which keeps records in relation to both private and public companies and partnerships, including changes in shareholders and officers. Due to recent amendment in the AML law, the Registrar of Companies will also keep records with information on the ultimate beneficial owners of the companies. As you can see on the next slide, the House of Representatives recently voted for the Prevention and Suppression of Money Laundering and Terrorist Financing Amending Law of 2021. One of the fundamental amendments made by this law is the implementation of the Register of Ultimate Beneficial Owner, currently as an interim solution to increase transparency. The Department of the Registrar of Companies announced on 16th of March 2021 the implementation of the interim solution by the collection of data for companies. Please note that there is a 6-month period from that date during which the information about the UBOs into the relevant interim reporting system should be submitted. So moving on to the next slide, please. According to the 5th AML EU directive, which was transposed into Cyprus legislation through the Prevention and Suppression of Money Laundering Activities laws, a UBO is defined as any natural person who ultimately owns or controls the entity in question through direct or indirect ownership of a sufficient percentage, 25% plus 1, of the shares, voting rights, or ownership interest in that entity, or who exercises such control via other means. If no natural person has such qualifying ownership or control, or no person under 25% plus 1 is identified, the natural persons holding the position of senior managing officials will be reported. Upon submission of requests to the Registrar of Companies during the interim solution, access to the UBO register is limited to competent authorities only, such as the police, tax authorities, the Central Bank of Cyprus, and SAISEC. The relevant supervisory authorities and regulators will have access to the information if they have a legitimate interest to do so. Therefore, information on the UBOs will not be publicly available for the time being. It must be noted that the interim solution has been developed to facilitate the collection of data required on the basis of the 4th and 5th AML directive. A period of 6 months, starting from the 16th of March 2021, will be given to all existing entities to submit their beneficial owners' data onto the system. In case of a change in the information of the beneficial owner, an entity and its officers must, within 14 days from the change, file onto the beneficial ownership register the information regarding the new beneficial owner or the change in the details of an existing beneficial owner. Entities registered following the 16th of March 2021 must, no later than 30 days from the date of their registration, file electronically to the beneficial ownership register all information in respect of each of their beneficial owner. So this is a quick overview of the legal framework applicable to the M&A process. analysis of which will now be provided by my colleague Maria Hini. Thank you.
Hello,
Thank you,
everyone. Sorry.
Thank you, Elena. Very interesting. So, Maria, I can't wait. So, go ahead.
Hello, everyone, again. In this point, I will analyze the procedures for the mergers and acquisitions in Cyprus, with focus on the cross-border merger, as well as some basic information about the joint ventures in Cyprus. First of all, I would like to provide you with the terminology of mergers and acquisitions. In Cyprus, we have the following three types of mergers and acquisitions. Firstly, merger between one or more existing companies upon dissolution without going into liquidation. This means that the assets and liabilities of the company, the target company, are transferred to another pre-existing one. Secondly, two or more companies transfer their assets and liabilities to a newly established company upon dissolution without going into liquidation. And thirdly, a company upon its dissolution without going into liquidation transfers all its assets and liabilities to the company which holds the 100% of its share capital. Next slide, please. In order to proceed with any type of merger, the steps to be followed are: there are no statutory provisions requiring disclosure of mergers and acquisition deals in Cyprus until completion of the procedure, where the relevant filings will need to be made with the company's registrar in respect of the change of shareholder in the company, similar to any change of shareholder in a private company. In practice, as usual, upon completion of the negotiation phase, both parties will proceed with their due diligence, which includes legal, tax, financial, commercial due diligences, etc., depending on the deal. For our convenience, I have summarized a list of documents which are usually requested, and those are the constitution and the latest corporate documents of the target company, collection and review of any existing mortgages, charters, or other obligations of the target company, examination of all annual returns and any board resolutions of the target company, the organization structure of the group, any shareholding agreements, intergroup and financial agreements, or any other agreements which may affect the merger, settlement of the annual government fees, confirmation of any pending litigation the company is involved with, and, depending on the type of company, key commercial agreements such as service and employment agreements. Next slide. The procedure for local mergers is quite simple, at least in comparison with cross-border mergers. Kindly note that the local mergers must receive court approval, the so-called merger order, before they can be conducted. In summary, in order to complete the merger process, what is needed is a restructuring plan, the creditor's consent, if any, minutes of the acquiring company, audited accounts and annual reports of both companies, and company petition for the merger order by the court. Upon proper completion of the aforesaid, the merger order is issued, which must then be presented to the registrar of companies in order for the latter to proceed with liquidating the target company without appointing a liquidator and without making the relevant publications with the official Gazette of the Republic of Cyprus. In the meantime, during the period of the finalization of the liquidation of the target company, we have the time to proceed with transferring all assets of the target company to the ownership of the remaining company, as well as arranging for the remaining company to undertake any existing obligations and debts of the target company. The local merger is deemed finalized once the registrar of companies issues the liquidation certificate for the target company. I would like now to emphasize on cross-border mergers, which are quite more interesting. Next slide, please. The EU Cross-Border Merger Directive facilitates the cross-border mergers. Next slide, please. Thank you. The EU Cross-Border Merger Directive facilitates the cross-border mergers of limited liability companies. A merger is only considered as cross-border if at least two of the participating companies are governed by the laws of different member states of the European Union. Next slide. The first steps to be taken by the company involve the drafting of the proposed terms of merger common to all merging companies by the directors and the approval by the board of the proposed terms of merger plan. The cross-border merger plan, its publication and filing, and the various reports that I will be mentioning now must be made available 30 days before the general meeting of the shareholders of the company, which will approve the cross-border merger. So for a cross-border merger, the directors of each merging company must prepare the common draft terms, which must contain full information about the companies and the outcome of the cross-border merger, which we then have to proceed with filing and publication in Cyprus of the directors' report, supported by an independent expert's report and the shareholders' approval. I must point out that the common draft terms must be filed with the registrar of companies at least 1 month before the date of the general meeting of the shareholders. By submitting the draft terms to the registrar of companies, the draft terms will be published in the official gazette of the Republic of Cyprus. Each of the merging companies must prepare a director's detailed report. This report should include an explanation of the legal and economic grounds for the merger, the share exchange ratio, and any valuation difficulties. The said director's report will be presented to the shareholders at least 1 month before the general meeting. Now, what is the independent expert's report? On the company's request, an independent expert is appointed by the relevant district court of Cyprus where the company is suited. The report should state information such as whether the terms are fair and reasonable, and indicate the methods used to arrive to their conclusions, and must be concluded at least 1 month prior to the general meeting. During the general meeting, following the presentation of the mentioned reports, the directors must give notice for a shareholders' general meeting to vote for or against the common draft terms. The resolution proposing the merger of the companies must be passed as a special resolution. A special resolution requires a majority of at least 3/4 of the members. Furthermore, the court may also request to convene a creditors' meeting. In such a case, the same percentage, that means 75%, is needed for the common draft terms approval. Following the general meeting, we move on to the verification procedure, which takes place in 2 stages. The first stage relates to the verification of the merger by the designated national authority of each merging company, and the second stage refers to verification from the designated national authority of the company resulting from the merger. Upon approval of the common draft terms, the company must apply to the appropriate district court to obtain the pre-merger certificate. In case that the surviving entity is suited in Cyprus, the court issues a court order approving and confirming the completion of the merger. I point that order must specify the date on which the merger is deemed to take place. Once the above-mentioned steps have been completed, a second application to the district court must be submitted within 6 months from the date of issue of the pre-merger certificate. Each merging Cyprus company, if more than one, must at this stage submit the pre-merger certificate, the equivalent of a pre-merger certificate issued for the non-Cyprus merging company, and the common cross-border merger plan approved by the shareholders' general meeting. Following the court's examination of all documents before it, a completion certificate is issued, which we must deliver to the registrar of companies. If the merger occurred by acquisition of one or more companies by another company, it takes effect from the date set by the court in the aforementioned court order. The result is that all the assets and liabilities of the target company are transferred to the acquired company. The target company's members become members of the acquired company, and the target company ceases to exist. As my colleague George mentioned earlier, Cyprus is a business hub with Cyprus holding companies frequently being used for international transactions, mostly because of Cyprus stability and zero tax on holding companies, our extended double tax treaties network, our business culture, and our English legal system. Most often, what we experience in Cyprus is the setup of a joint venture holding companies as part of an international or a foreign M&A deal which will thereafter invest in foreign asset or businesses. I will therefore very quickly refer to the joint venture options in Cyprus. Next slide, please. As per the provisions of companies law, there is no actual definition of a joint venture in Cyprus. However, there are 4 types of joint ventures which can be identified in current practice. Those types are the contractual joint venture, partnership joint ventures, corporate joint ventures, and European economic interest groupings. Next slide. The contractual joint venture is the most common used joint venture in Cyprus. This type does not require a separate legal entity. It only requires a contractual agreement between the parties. Such type of joint venture is usually used for large construction projects, especially for the context of public tenders. The advantages of this type are the flexibility with respect to the operation and termination of the agreement, the contract law in Cyprus, which is based on common law provisions, no company registration requirements, time-efficient solution, no joint liability since each participant is liable towards third parties for his or her own acts or omissions, and last but not the least, possible independent tax planning for each party. However, due to lack of legal entity existence, there might be a difficulty in establishing commercial contract with third parties. Furthermore, due to lack of legal framework, the agreements need to be drafted very carefully. In addition, there is a risk the court to classify the relationship of the partners with joint liability instead of each partner to be liable based on each one's actions. Next slide, please. The partnership joint venture is not so common type of joint venture. This type constitutes a relationship governed by the relevant statute, which specifies the liability of each partner depending on whether the partnership is limited or general. The business assets and any IP contributed by each party become property of the partnership. Partnerships are tax transparent. Accordingly, taxation occurs at the level of the participants and profit and losses occur to them. There are also some benefits for the partnership joint ventures. Generally, there are fewer formalities than in case of corporate joint ventures. Registration requirements exist, but not requirements for disclosure of the actual partnership agreement. Although the partnership does not have a legal personality, it may sue and be sued in its own name and may trade under its name. Attribution profits only to the partners and not to the partnership. And there is also independent tax planning possibility for each participant regarding losses incurred and profits earned. Due to the extensive network of double tax treaties maintained in Cyprus, wide options may be available in this respect. On the other hand, partners should be careful since significant powers are given to unlimited partners. Liability comes with involvement in the management and control. Unlimited liability of general partners towards third parties. Solutions alleviating the effect of this may be possible. Tax transparency may not be beneficial where the partners are natural persons, as they might be taxed at higher rates. However, with appropriate structuring, this may be avoided. Next slide. Corporate joint ventures are created through the establishment of a common legal entity that is separate from its participants. A shareholder agreement is usually drafted in parallel with this type of joint venture. This type is more appropriate where it is expected that the joint venture will need to enter into contractual agreements with third parties due to limited liability benefits. This type of joint venture is usually used by international clients aiming to benefit from the network of double tax treaties maintained in Cyprus. The benefits of this joint ventures type are the limited liability of the participants to the joint venture itself. Participants control the company by appointing a board of directors, which can be professional directors as well. A corporate joint venture is governed by the provisions of companies law, which offers a greater degree of stability than other options since the relationship is not purely contractual. and the low corporate taxation of 12.5%. The disadvantages are less flexible than the other structure due to the provisions of the company's law. Governance and control questions might need to be addressed. Operational costs may be an issue due to the greater formality of the parties as well as the entity. Typical adoption on restrictions and conditions for the transfer of shares. And if participants are natural persons residing in Cyprus, the corporate profit and dividends might be subject to taxation. Next slide, please. European economic interest groupings is the last referred type of the joint ventures. This type was established in order to promote economic activities between member states. This type bears an unlimited joint liability of the participants for the debts and liabilities of the European economic interest groupings, but what makes it quite interesting is the possibility of exclusion from liability of one or more members for a particular depth of liability. This type of joint venture enjoys tax transparency and profits or losses are taxable separately by each party. Next slide, please. My section of the webinar couldn't be finalized without mentioning the impact of COVID-19 in Cyprus. Unfortunately, the situation with coronavirus was and still is not so promising all over the world. There is no sector left unaffected by COVID-19, and so does merger and acquisitions deals. We have noticed that the local market follows the international tendency, which means deals that were close to implement the merge being put on hold, and those deals which were in the process of finalization, they agreed to adjusted rates. Nevertheless, new deals are expected to be seen now, especially on travel and hospitality industries, which are the ones mostly affected by the pandemic. As Angelos mentioned, this can be the era of distressed M&As. Another challenge for Cyprus was the announcement of Brexit. We were wondering how Brexit would affect Cyprus. The truth is that today, it seems that the whole situation with Brexit has a positive impact for Cyprus, of course in lesser extent than Ireland, but still Cyprus is very closely connected with England. This is due to several reasons, such as the legal framework in Cyprus, which is based on common law. Cyprus is an alternative solution for the UK businesses in terms of entering the EU. Last but not the least, our favorable tax system in combination with all the above mentioned reasons makes Brexit to seem beneficial for Cyprus and not the other way around. I will now let my colleague Michael to analyze tax benefits. Thank you all for your time, and it will be my pleasure to answer any further questions.
Thank you, Maria. Very explanatory, very detailed. I'm pretty sure that from the description you did about joint ventures, the ones that are mostly used on almost on a daily basis are the corporate JVs when investing in foreign assets or businesses. Anyway, thank you again. Michael, it's your turn. Let us know about taxes.
Thank you, Angelos. Thank you very much. Hello, everybody. Hope you're enjoying the webinar so far. We will now continue with Cyprus tax insights and benefits. Let's jump straight in. So what exactly are the tax benefits of an approved merger or reorganization? The answer to this being there are no taxes whatsoever on the transfer of any assets. There are no transfer fees or stamp duty. No balancing statement is required for the transferring of assets from one company to another. No capital gains tax is charged if transaction involves the transfer of Cyprus immovable property, and any losses carried forward of the transferring company can be transferred to the receiving company. Slide, please. However, regarding the before-mentioned benefits, there are anti-avoidance provisions in place. As reorganizations are a tax-free tool, the Commissioner reserves the right to void an approval for reorganization if of the belief that no genuine commercial or financial reasons existed for the reorganization. Basically, there being no commercial or economical rationale. Conditions may be imposed by the commissioner as to the holding period of the shares received under the reorganization. So to avoid any surprises, strict adherence to the rules imposed within the types of reorganizations is necessary. Otherwise, the commissioner may deem the reorganization void to the contrary. It is important to note that in the case where the commissioner may consider the reorganization as void, all benefits previously mentioned will not apply. Slide, please. Going forward, I would like to link the before mentioned with the benefits of Cyprus being an EU member state. We tend to say many times that Cyprus has benefits of being in the EU. The following are some examples. The EU Merger Directive, whereby the EU Merger Directive allows for all reorganization types between EU member states. The Parent Interest and Royalties Directive. This states zero imposition of withholding taxes on interest and royalty payments between EU member states, provided a minimum 25% capital holding exists. The Parent Subsidiary Directive, again there being zero imposition of withholding taxes on dividend payments between EU members, provided minimum 10% capital holding exists. Do note that this also has an anti-abuse rule where the benefit is not granted if the arrangement is considered as non-genuine, again implying no commercial or economic rationale. Slide, please. Further to the EU directives, on a group level, group member companies may surrender losses from one loss-making member to another profitable one. So the inclusion of a Cyprus company in a group structure, including an EU member state company and a non-EU member state company, could provide for many benefits if correctly structured. On a company level, in Cyprus, tax-adjusted losses can be carried forward and set off against tax-adjusted profits for the next 5 subsequent years. Losses cannot be carried back. As a general note, the carry forward of losses cannot occur in the case where if within a 3-year period there is a change in ownership and substantial change in the nature of the activities. Slide, please. Moving on to another topic, a very favorable tax-reducing tool is the new Cyprus IP box regime. The previous IP box regime, which Cyprus applied, had many flaws, as an 80% deduction was granted without any real justification. This was not to the liking of many other countries, and so it rightly needed to be changed. As per the provisions of the new Cyprus IP box regime, a qualifying intangible asset is defined as an asset which has been acquired, developed, or exploited by a person in the course of carrying on a business which is the result of research and development activities. Qualifying intangible assets specifically comprise of patents, computer software, other intangibles that are non-obvious, useful, and novel. Trademarks and copyrights included in the previous IP box regime are specifically excluded from the new regime. Slide, please. The new IP box regime follows what is called the nexus approach, whereby a direct link between qualifying income and own qualifying expenses is essential for the intellectual property to qualify, and in this case, 80% of qualifying profits generated by qualifying assets is deemed to be a tax-deductible expense. In no case under the new regime are you simply guaranteed an 80% deduction. In order to get the full benefit from the IP box regime, a company should perform the research and development activities either itself or through a R&D work outsourced to non-related parties. Any R&D work subcontracted to related parties and acquisition costs are not considered to be qualifying expenses. Slide, please. Another favorable tax-reducing tool is the notional interest deduction. The main intention of notional interest deduction, NID, is to provide a company which has taxable incomes generated from own funds, new equity, to have a relative notional interest deduction. This is an incentive provided to any new project used in order to finance taxable income generating activities, as long as this new equity is in the form of share capital or share premium. The exemption is limited to 80% of annual taxable income during the whole life of the investment, and it is applied by deduction in the tax computation calculated by multiplying a reference rate to the amount of equity. It is important to note that this is not only applicable during the first year. A simple explanation I like to use is that a company financing a project via debt is allowed as a tax-deductible expense the loan interest payable, whereas a company financing a project with own funds in the past did not have this benefit. So introduction of NID in a way rectifies this. The NID reference rate is defined as the interest rate of the 10-year government bond yield of the country in which the new equity is invested. This is published annually, increased by 5%. The reference rate for 2020 applying to Cyprus-based investments was 5.53%, which is the 10-year bond yield of Cyprus, 0.536% plus 5%. The premium used to be 3%. However, as from 1st of January 2020, this was amended to 5%. Slide, please. Allow me to walk you through a short practical example. Scenario A, we have an investment worth of euro 10 million. As mentioned previously, the reference rate in Cyprus is 5.536%. NID in this case is the amount of investment times the reference rate. So this is euro 553,600. Let's say our company has accounting profits before tax of euro 1 million. As previously mentioned, the maximum NID deduction is restricted to 80%, which is 800,000. So now the NID which will be granted is the lower of 3, the NID calculated, and 5, the maximum NID tax deduction. In this case, we'll take the NID at 0.3, which is 553,600. Once this is deducted from the euro 1 million accounting profits, there is a taxable income of 446,400. Tax charged 12.5% on this will give you tax of euro 55,800, giving you an effective tax rate of 5.58%. Now scenario B. Again, we have an investment of euro 20 million. Reference rate, as previously mentioned, 5.536% of Cyprus. The NID in this case amounts to euro 1,107,200. In this case, our company has accounting profits before tax of 1.2 million. And so the maximum NID tax deduction restricted to 80% is 960,000. The difference in this case to a previous scenario is that now in this case, we will take the maximum NID tax deduction, the 960,000. This will be deducted from the accounting profits before tax, giving you taxable income of 240,000. Tax charged on this will give you a tax of euro 30,000. In this case, the effective tax rate is 2.5% and has fully been utilized. The new IP box regime and NID are two very strong tools which can provide maximum tax optimization and can be used together. However, the maximum deduction, if both tools are used, is 80%, not more. And this will reduce the tax rate to an effective 2.5% if all conditions are applied. The new IP box regime is in line with BEPS Action Plan 5, and the NID follows a concept as adopted by a number of other countries and is generally accepted by the OECD guidelines. This is a justification that these are acceptable tax optimization methods, and my personal belief is that these are here to stay. Slide, please. Some further tax benefits regarding non-Cyprus tax residents. On the payment of interest to a non-Cyprus tax resident, legal or physical person, there is zero withholding in all cases, irrespective of any double tax treaty clauses. Again, the payment of a dividend to a non-Cypriot tax resident, legal or physical person, zero withholding tax applies in all cases, again, irrespective of any double tax treaty clauses. Payment of royalties or any other intellectual property rights to a non-Cypriot tax resident, legal or physical person, a maximum 10% withholding tax applies on the gross amount of such payment only if the royalty rights were used in Cyprus. There is no tax on profits from the sale of securities that classify as titles. A detailed list is provided by the Cyprus tax authorities. All of the before mentioned, plus the very low tax rate of 12.5%, makes Cyprus a very attractive jurisdiction. Slide, please. Cyprus also has an additional tax being Special Defense Contribution, SDC tax. SDC tax is a tax charged in Cyprus on passive incomes. Cyprus tax resident individuals for SDC purposes includes the domicile concept. As such, an individual who is Cyprus tax resident, as per the income tax law definition, but not domiciled in Cyprus is exempted from the chargeability of SDC on all passive incomes, such as dividends, interest, and rental income. What this basically means is that for a non-domiciled Cyprus tax resident, dividends and interest of a passive nature can be received tax-free. Non-domiciled tax residents are those that were not tax residents of Cyprus during 17 out of the last 20 years and do not have a Cyprus domicile of origin. Cyprus has come a very long way, has introduced all ATAD anti-tax avoidance measures into Cypriot law. Just a few days ago, the Cyprus Parliament voted into law the provisions of DAX 6, has corrected tax incentives to be acceptable by OECD and BEPS. And so, although there is still always room for improvement, Cyprus has come a very long way. Thank you for listening. We'll now pass you over to my colleague, Ms. Andrea Psara.
Thank you, Michael. Andrea, I will let you proceed immediately. Thank you.
Sure, thank you, Angelos. Good afternoon, everyone. It's a pleasure really to be here with you today, and thank you for joining us. Moving on to my part of the presentation, mainly M&A disputes can arise in 3 different stages. Next slide, please. Perfect. So the first stage is at pre-signing. The second stage is between signing and completion, and the third stage is post-completion. At the pre-signing stage, we may encounter issues relating to a breach of a non-disclosure agreement or a breach of a memorandum of understanding, and whether those documents create legally binding obligations. But usually, it is at the second and third stages that more disputes can arise. If a transaction is not signed and completed on the same day, and there is lapse of time between signing and completion, then disputes may arise from the non-fulfillment of the conditions precedent. And this is important because the uncertainty created by the COVID-19 pandemic, with the lockdown in different jurisdictions and regulators or merger control authorities being understaffed or working on rotation, the time frame required to satisfy conditions for enabling completion to take place may become longer. For example, we may experience delays in obtaining merger control clearances or processing court-related applications. Though I do have to say that in Cyprus, especially during the last month, we can say with confidence that things have already improved, and hopefully these delays will soon be behind us. We often see that when there is a crisis, there is an opportunity, and that is why we feel that the changing landscape may provide increasing opportunities for M&A deals. And aside from traditional M&As, we do expect the pandemic to lead to an increase in what we call distressed M&A deals, where distressed companies are looking for buyers or investors with an increasing appetite for risk. Especially in relation to distressed M&As, we expect contractual drafting to change towards a more buyer-friendly provisions, and this is where material adverse change clauses and price adjustment mechanisms enter the game. But I do note that these can be more vulnerable to disputes. I note that there is no Cypriot case law in this area, but as a note of caution, the Cypriot courts have historically applied the principle known as sanctity of contract, which basically means that contracts must be adhered to. So where available, relying on a material adverse change clause may on the surface appear to be a safe way for exiting an agreement, which has been negatively impacted by the pandemic. However, in reality, a buyer who has a change of heart may face uncertainty as to whether reliance upon a material adverse change clause will be upheld by a Cypriot court. And if not, the buyer may then face a damage claim for wrongful termination. So I would say that the concept of materiality in this context imposes a high threshold. Moving forward to the third stage, that is the previous slide, please. Thank you. So during the post-completion stage, we can face claims mainly for breach of warranties and indemnities, misrepresentation or even fraud claims, and depending on the terms of the transaction, we may also face claims relating to price adjustment mechanisms and deferred consideration. That being said, price adjustment clauses in distressed M&A transactions are more favored by the buyers who may seek adjustment based on completion accounts. On the other hand, the seller will try to negotiate for a fixed purchase price based on the company's value at signing or at an earlier date. In practice so far, fixed price consideration is the norm because of the uncertainty over the consideration that may be paid. Having said that, we do recognize that price adjustment clauses are becoming more popular and they're here to stay. And this is where contractual drafting is particularly important in order to establish a mechanism that would minimize, as far as possible, the risk for a dispute. Next slide, please. So moving now away from M&A clauses which may give rise to dispute, we would like to give you a short description of the legal tools that are available in Cyprus for aggrieved shareholders. As my colleagues mentioned earlier, Cyprus is a popular jurisdiction to establish asset holding companies and joint ventures, and the corporate legal framework is particularly friendly for doing business. Although at the stage of incorporation, a fallout is not something that we really want to think of, it is important to understand that aside from contractual exit provisions, such as triggering redemption of shares in case of redeemable preference shares or put options, Cyprus affords protection to aggrieved shareholders, and this protection has been modeled on English law. As you may be aware, directors owe fiduciary duties to the company that they serve, including, for example, the duty to act in the best interest of the company and promote the success of the company, and the duty to avoid conflicts between their own interest and the interest of the company they serve. So the most likely claim against directors is that in pursuing a transaction, they acted in breach of their duties. As a general rule, the cause of action lies with the company and not with individual shareholders. That being said, there are three specific remedies available to individual shareholders. The first one is a petition to wind up the company on the basis that it is just and equitable to do so. The second is a remedy on the basis of what we call oppression on the minority, and the third remedy is a derivative action. All these remedies are, of course, familiar to those of you in common law jurisdictions. So in relation to the first remedy, an aggrieved shareholder may petition the court to wind up the company on the ground that it is just and equitable to do so. So this remedy is available in cases of deadlock and complete breakdown or loss of confidence in the relationship of the parties, or where there was an understanding that the shareholder would be permitted to participate in the management of a company, but he or she was excluded from doing so. Next slide, please. In many cases, however, and in particular where the company has value, the winding up may not be an appropriate remedy. And this is because the winding up of a company may result in the sale of the company's assets at a breakup value without regard to the value of the goodwill or know-how of the company. If the company has long-term debts or loans, these may be called upon and become due immediately. And of course, depending on the value and type of the company's assets, the liquidator's expenses may be high. Next slide, please. So to mitigate these cases, Section 202 of the Cypriot Companies Law gives oppressed minority shareholders an alternative remedy to winding up on just and equitable grounds. At this point, I must note that Section 202 of the Cypriot Companies Law corresponds to Section 210 of the UK Companies Act 1948. So English cases decided based on Section 210 are still relevant in Cyprus in interpreting our Section 202 and what amounts to oppressive conduct. And as a side note, I would like to mention that in the UK, legislative developments resulting to what is now Section 994 of the UK Companies Act 2006 repealed the test of oppression on the minority and replaced it with a test of unfair prejudice, which is a much more relaxed test than ours. Next slide, please. So Section 202 of the Companies Law can be triggered if the company's affairs are being conducted in a manner that is oppressive to the aggrieved members, and the court would have been willing to issue a winding up order on the basis that it is just and equitable to do so, but the issuance of a winding order would have unfairly prejudiced the oppressed members. Next slide. So, pursuant to Section 202, an oppressed shareholder may seek a court order for either regulating the way in which the future affairs of the company will be conducted or a buyout remedy. And in practice, the order that is normally sought is for the oppressed minority shareholders to be bought out by the majority shareholders at a price to be fixed by the court. Next slide. So what does amount to oppressive conduct for the purpose of Section 202? Oppressive conduct has been interpreted by the courts to mean conduct that is burdensome, harsh, and wrongful, and not simply unfair. An isolated act cannot prima facie constitute oppression. The conduct complained of must be of a continuing nature and persistent. So the mere fact that a shareholder lost confidence in the manner in which the company's affairs were being run, or had been outvoted, or was dissatisfied with the conduct of the company's affairs on grounds, for example, of policy or efficiency, is not sufficient for establishing oppression. There must be lack of probity or fair dealing to a shareholder in relation to his proprietary right as a shareholder. Next slide, please. So moving to derivative actions, this is a common law creation, and it basically allows a shareholder to step in the shoes of the company and bring a derivative action for a wrong that is committed to the company. Given that the company is a separate legal entity from its members, the proper plaintiff for a wrong that is committed to the company is the company itself. However, in realization that the company is managed by the board of directors, which is basically controlled by the majority shareholders, there may be instances where the board of directors will not pursue an action. And this is because if directors and the majority shareholders are involved in the wrongdoing, they would of course not want to bring an action against themselves. Therefore, aggrieved shareholders that represent the minority are usually precluded from complaining of actions that are approved by the majority. Next slide, please. So a derivative action is an exception to the proper plaintiff rule, and it is called derivative because the shareholder's right to sue is not personal to him, but it derives from a right of the company which is not able to exercise. So the aggrieved shareholders here seek to enforce the company's legal right, which may also include a breach of director's duty. So what are the requirements for succeeding in a derivative action? There are two elements that need to be satisfied. The first one is that the alleged fraud must constitute fraud against the minority. And the second element is that the alleged wrongdoers are in control of the company. Control exists even if shareholding is 50-50, as wrongdoers here can still prevent the company from initiating a legal action by passing a simple majority resolution at the general meeting. So the question of control is ultimately whether the company could act independently in order to protect its interests. In relation to the first element of fraud, I would just add that it is not fraud in its strict legal sense, but it includes circumstances where the majority are trying to appropriate to themselves money, property, or advantages that belong to the company, or in which the other shareholders are entitled to participate. Next slide, please. So just as a final note, I would like to add that the increasing use of Cypriot companies as holding companies means that we often encounter shareholder disputes all the way from the holding company to its subsidiaries. The law on derivative actions has recently developed so that in certain circumstances, a multiple derivative action can be brought by a minority shareholder in a parent company for wrongs done to the parent company's subsidiaries. So in this case, the minority shareholder will be claiming damages on behalf of the subsidiaries. So ultimately, which course of action is suitable in a given circumstance depends on the objectives of the aggrieved shareholder and the facts of the case. For example, if the objective is a way out, then seeking a buyout on the basis of oppression of the minority is more appropriate.
Thank you very much, Andrea. Very informative. So you are pretty much, in a nutshell, giving the explanation that parties to an M&A through Cyprus should feel secure having common law and English law as their backup through Cyprus courts, not only in terms of the actual target company in an M&A, but also on the below subsidiaries.
Yes, exactly.
Excellent. So the stage with the presentation has been completed, and thank you, everybody. We have quite a few questions, if you don't mind giving brief answers, because we already exceeded the time. So the first question that came up already is, it refers to Maria Heaney, whether can a subsidiary absorb its shareholder in restructuring instead the other way around. Maria, if you don't mind, I can very quickly answer this. Of course, yes, you can. It is possible for a subsidiary to take over, to absorb its parent under the income tax law of Cyprus at the definition of mergers. Now, the next question goes to Michael. Michael, what is the status of Netherlands and Cyprus double tax treaty that was sent to Netherlands Parliament in fall 2019? Do you have some comment on that? I don't.
Angelos, this is a very good question. As I am aware, a double tax treaty was agreed with the Netherlands somewhere around September 2019. However, for some reason, this has not come into effect. The draft, which was issued, reportedly provided for 15% withholding tax on dividends. Interest and royalties were to be exempt from withholding tax. As the issue of double tax treaties has been considered, allow me just to add some general information. Cyprus and the UK have signed a new double tax treaty around March 2018. This replaced the treaty signed between the two countries in 1974. Brexit will not give rise to any changes to the new treaty signed, as it seems. Also, Cyprus and Russia have agreed to the amendment of the double tax treaty, and this came into effect as from 1st of January 2021. The main changes being the withholding tax rate on dividends to 15% and the withholding tax rate on interest from 0% to 15%. Malta and Luxembourg have also agreed to the changes with Russia. The Netherlands and Russia are currently in a disagreement over the treaty changes.
Oh, that's good.
Thank you, Angelos.
You're welcome. So the next question I have here is again for Maria. Maria Ilia asks, what are the common approaches to evaluate a company in Cyprus that is being sold? So basically, I think you already answered that.
Yes,
but,
as mentioned to my presentation, an in-depth due diligence should be done in order to make sure that the operational due diligence, that means legal, financial, and tax due diligence, have been carried out properly. Thus, the interested party actually should proceed with an engagement of an expert, let's say our firm, to proceed with the due diligence.
Excellent. So it's a legal and financial due diligence.
Exactly, and a tax.
And tax. Elena, I have a question for you on the regulatory side. Can Cypriot regulatory authorities block a deal?
So currently there are no regulatory restrictions in Cyprus. We did notice, though, a number of major economies such as France, Germany, and UK introducing particular measures, temporary measures, according to which governments may exercise their discretion to block certain potential takeovers. In specific, in Germany, the government introduced new rules which enable the government to block acquisitions by non-EU buyers that present potential interference. Likewise, in France, acquisition of more than 10% of voting rights by non-EU buyers requires government's approval in strategic sectors. But in Greece and in Cyprus, no such measures have been introduced. Cyprus has the option, though, to exercise its discretion and introduce regulatory restrictions on acquisitions. Thank you.
Thank you. Thank you, Elena. And the last question we have, and I think we are closing, it's on you, Andrea.
Sure.
Whether buyers in an M&A deal can invoke a force majeure clause, I assume due to the pandemic.
Well, it depends on the wording of the clause. If the force majeure clause includes the word pandemic or epidemic, then this will almost certainly include COVID-19. However, I would say that the ultimate question here is whether COVID caused the inability of the party to perform the contract. So in order for this clause to be successfully invoked, there must be, for example, a prolonged period of breakdown, which makes it impossible, for example, for the buyer to effect payment or for the seller to deliver the CPs. So I see difficulty there to invoke force majeure clauses successfully, but in M&A transactions, but I feel that it may be used to renegotiate timing and obtaining an extension of time to complete the conditions precedents and flexibility on payment delays.
Thank you very much, Elena. We have another quick question here for Michael. Michael, you are the last one. I'm sorry. The question, are cryptocurrencies considered as titles by the tax authorities and exempt from tax? If you can give a short answer so we can close this. Thank you.
That's another very good question. Cryptocurrencies are not included in the list considered as titles. Allow me to say that I feel that this is currently somewhat of a gray area, as I have heard and read many different opinions. So this is pending further guidance from our tax authorities.
Excellent.
Thank you, Angelos.
Thank you very much, Michael. I think we are done. I don't see any further questions in the panel. I hope this presentation was as interesting as for everybody as it has been for us. I really enjoyed it, and I believe it was an enjoyable time for us all on this panel. Thank you, and we can we can close it.